Quote, in response to Justice Scalia's recitation of American history in which he documented the purpose and intent of the founders and of the First Amendment, Justice Souter's reply was, so what? Souter admitted that he and the others would apply the Constitution in a manner unanticipated by the founders, that the majority of the justices admitted that they do not adhere to an immutable rule of law, and that they have no agreed upon standard, that they make up the rules as they go. James Madison has something to say to our U.S. Supreme Court. Listen to this. This is my favorite James Madison quote. Here's what he's quote. Do not separate text from historical background. If you do, you will have perverted and subverted the Constitution, which can only end in a distorted, bastardized form of illegitimate government. James Madison. The second example of abandoning the rule of law is the Kelo case. If you'll remember, the U.S. Supreme Court decided that the government could take the private property of a private individual. It's not actually take, they can force them to sell it, eminent domain. The government can force them to sell it to the government, the private property, and so that the government can sell it to another private individual, because that other private individual is going to use that property in a way that's going to generate more taxes for the government. And that is for the common good, for the greater common good, right? Again, the U.S. Supreme Court has changed the language of the Constitution. The Constitution says what for eminent domain? Public use, not public good. Taking private property for public good is Marxism. It has no foundation in American jurisprudence. In America, we were founded on the premise that all private property and all individuals are unique and not interchangeable. If you go to a court of law with a bill of sale for a piece of property, what do you get in a court of law? You get what's called specific performance. You get that piece of property. You don't get money in replacement for it. You don't get a different piece of property to replace it. Well, you know, the judge can't say, oh, this property over here is just as good, you get that. No, you get specific performance, you get that piece of property because it's unique, not interchangeable, sacred. One of your inalienable rights is the right to your property. John Adams said, property rights must be secured or liberty cannot exist. The moment the idea is admitted into society that property is not as sacred as the law of God, and that there is not a force of law and public justice to protect it, anarchy and tyranny commence. John Adams. Well, what's the solutions? That's what you want, right? The solutions. I have been very, very tricky. I have given you all the solutions already. The first solution is the doctrine of non-acquiescence. That's where our constitutional officers have the constitutional courage to do their constitutional duty to defend the Constitution. Under our system, as we read, every single one of our state and federal legislators has taken an oath to defend the Constitution. That means they have taken an oath not to pass any law that is unconstitutional or that tramples your God-given inalienable rights. Because the only reason we have government is to do what? Secure our inalienable rights, and that's the only reason we elect anybody into offices of government, is to secure our inalienable rights. You will hear legislators tell you it's not their business whether the law is constitutional or not. That's for the courts to tell them. No, that's not our system of checks and balances. Why do we have them take an oath if that's not their business to defend the Constitution? And the Constitution is a limit on whom? Government, right? It's not a limit on us, right? So what is their oath? Who are they supposed to be protecting the Constitution from? The other branches of government and the other officers of government, right? That's what that oath means. And every one of our justices and judges, state and federal, has taken an oath to defend the Constitution. That means they have taken an oath that they're not going to take any law and apply it to you in a manner that's unconstitutional or tramples your God-given inalienable rights. And then the part that most Americans have forgotten, Every single executive officer, your sheriff, your mayor, your police chief, your governor, your president have all taken an oath to defend the Constitution. That means they have taken an oath not to enforce any law or court order that is unconstitutional or tramples your God-given inalienable rights. They have just as much a duty not to enforce an unconstitutional law or court order as to enforce a constitutional one. You will hear executive officers tell you that they are just to enforce whatever law or court order comes down the pipe. No, that is not the oath they took. They took an oath to defend the Constitution, and their job is to secure our God-given inalienable rights. If you ever wondered what it is that's supposed to keep us from becoming a Nazi Germany, this is it. We have divided the power among the different branches of government, and we've made every single one of them take an oath to defend the Constitution and not to simply do what another branch of government tells them to do. That is the doctrine of non-acquiescence. We have to start holding our constitutional officers accountable to us. But most Americans don't even know that is their job, and that's what they're supposed to be doing. Okay, so doctrine of non-acquiescence. We went over this. Disestablish, right? Congress can disestablish courts. We don't have to, if we can't trust them if they're doing us more harm than good, why do we have a Ninth Circuit? Why do we have a Fifth Circuit? Why do we have a Middle District of Ohio? Do you have a Middle District of Ohio? Northern, I know you have a Northern District. Northern District of Ohio. If they're doing us more harm than good, get rid of them, right? We can defund courts. We can defund the federal courts. I think that's something people are not remembering at all. They're like, what, Congress doesn't have control over the executive branch, or Congress doesn't. Congress has all control because Congress has all the money. You can they can make whatever laws they want, and the president can have whatever executive officers executive orders he wants, and the judicial branch can come up with every decision they want. But if they don't have money and they have no way to enforce it, they have nothing, right? They have pieces of paper. And we can restrict jurisdiction. If we cannot trust the courts with Pledge of Allegiance cases or marriage cases or you name it, then we can have them not have jurisdiction. The federal courts not have jurisdiction over those cases. Congress can do that. Oh, this one I didn't talk to you about, reduce the number of justices. If you didn't know it, our Constitution doesn't tell us how many justices we have to have on the U.S. Supreme Court. We have had as few as 5 and as many as 15. Why don't we have like 8 and let them 4 themselves to death and never do us any harm, right? Why don't we do that? It doesn't say we can't do that. And the last one, everybody loves, remove judges for bad behavior, right? Anybody curious about what bad behavior is? You curious? Okay, we're on the last leg right here. Here you go. Ready? In 1803, federal Judge John Pickering was impeached for issuing an order which contradicted an act of Congress for judicial high-handedness, drunkenness, and blasphemy. In 1804, Justice Chase was impeached for judicial high-handedness and for excluding evidence from a trial. In 1830, federal Judge James Peck was also impeached for judicial high-handedness. In 1862, federal Judge West Humphreys was impeached for supporting the secession movement. In 1904, federal Judge Charles Swain was impeached for financial improprieties and judicial high-handedness. In 1912, Federal Circuit Judge Robert Archibald was impeached for judicial high-handedness and misconduct. In 1926, Federal Judge George English was impeached for judicial high-handedness and for profanity. My personal favorite, in 1933, Federal Judge Harold Lauterbach was impeached for seeking to hide his assets during a personal divorce proceeding. Gerald Ford, when he was in the U.S. House of Representatives, was considering starting impeachment proceedings against Justice William Douglas. At that time, he correctly noted that bad behavior or impeaching a justice or a judge, federal judge, is not tied in any way to criminal or civil penalties. It does not have to be a crime. It doesn't have to ever be a crime. In other words, what U.S. House of Representatives deems as bad behavior is bad behavior. And who is supposed to be the U.S. House of Representatives? You and I, right? We're supposed to be the U.S. House of Representatives. So in other words, bad behavior is whatever we deem to be bad behavior. In other words, the bottom line is, contrary to what they are busy telling us day in and day out, we hired them, we can fire them. I'm going to end with the quote with which I started by Thomas Jefferson. The issue today is the same as it has been throughout all history, whether man shall be allowed to govern himself or be ruled by a small elite. Thank you.